Good morning, Mr. Garrett. Sir, you're charged with terroristic threat of a family or a household member. That allegation kicks it up to a Class A misdemeanor, so you were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On February 25th, 20.
Hold up, a terroristic threat charge doesn't mean terrorism the way most people think. Under Texas law, it often refers to making a threat of serious harm that causes fear, even within a family setting. It's less about organized violence and more about the emotional impact of a threat. The idea is that causing someone to genuinely fear for their safety is serious, no matter the context. But here's the question. Should words said in the heat of a family argument be treated the same as violent threats made against strangers? What's your take?
25, the officers were dispatched to a residence in Harris County, Texas for a disturbance with an unknown weapon at approximately 5:49 p.m. And upon arrival, the officers met with the complainant, who stated she is the mother of the defendant and they live together. The complainant stated that day her healthcare provider came to her residence to help her as she is disabled. And the complainant stated the defendant was in his room playing loud music, and the complainant asked the defendant to turn it down while her provider was there. The defendant did turn it down, and as soon as her provider left, he turned the music back up. The complainant requested the defendant turn the music down again, and a verbal altercation ensued over the music and money, and the defendant started to rip up family photos. The complainant tried to stop the defendant, but the defendant grabbed the complainant by her arms and pinned her against the wall. The complainant stated she did not feel pain, but that the defendant said to the complainant that if she continued to touch him, that the defendant would break the complainant's jaw. The defendant was on the scene and refused to speak to officers.
Okay. Mr. Garrett, I'm going to find that there's sufficient probable cause to go forward with your case. Do we know what mom wants?
See if a rip was attempted, Your Honor, and unsuccessful.
We have a call scheduled later this afternoon. She won't be available until afternoon.
This is a problem. I normally order in these types of cases that you're not to go back to his place. So if you don't have anywhere else to go to, what happens? You have to be careful in these situations, Mr. Garrett. So let's do this. How old are you, sir? I'm going to give you a lawyer today. I want you to talk to the lawyer so we can figure something out. I don't want to put you out on the street, but I got to protect every person here. You understand? So I'm ordering you as a condition of your bond not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're using.
Judge Boyd is laying it down. This is what you call a true courtroom reality check. He's firm, but fair, walking that fine line between compassion and accountability. You can see he's trying to protect both the mother and her son, making sure the home stays safe while still holding him responsible for his choices. It's a delicate balance that not every judge gets right. But what do you think? Is Judge Boyd being too lenient by letting him return home, or too strict by warning him that another failed drug test could land him in jail?
Anything, I will revoke your bond, put you in jail. Do you understand? You're not to be in possession of weapons as well. And you're not to have any threatening or harassing contact with mom. If I find that you do, likewise. You got out of jail because we gave you a free bond. What happens if we put it at 5 to 10,000? If you don't have anyone to bond you out, you'll be stuck like Chuck in there until this thing's over with. And it takes a long time just to get a 911 tape. You understand? So I'm going to have you sign a reset. Let me have you take a seat in the jury box. I'm going to find your lawyer and then we'll go to it. Come on. According to what I was reading here, he's lucky that it's not filed an assault. And the thing is that do we let him go home? What's going to happen if not? Because come up, Mr. Garrett. When I have these types of cases, normally I don't let the people go back. Because or do you want to talk first and then you come?
Can we step down?
Yeah. So the first thing I told Mr. Garrett is that he's not to use any illegal substances and that you're going to get tested. I want you to know now that I will test you 40 days to 45 days from today. If I find that you're using anything illegal, including THC, I will revoke your bond and put you in jail. Do you understand?
Yes, sir.
Okay. When I have these types of cases, I typically prevent the person here to have any contact with or to go back to the house where the complaining witness lives. Does he currently live there now?
He does.
It's
He's
going to be a problem. So how, because what the last thing I want, Mr. Garrett, are more words to exchange and you end up with another case because there's now bad blood between you two. That's the last thing I want. So how do we prevent that from happening, Abe? What do we do?
Judge. I request that the court order no harmful injurious contact with the CW. Based on my reading of the case, it doesn't appear that a no contact order is required or warranted at this point, Judge.
From what I read, it could have been an assault that you could have been charged with in addition to this case here. What do you think? Say.
Our state would request, we've got a call scheduled at the state would request some sort of cooling off periods, right? There would be no contact order, very dangerous cases, we usually have very cooling off periods since these are fresh charges.
Do we put him on the street though? Because essentially that's what's going to happen. He's 22, right?
Yes, sir.
We can also, hold off till she said noon.
Yeah.
If it would be okay with the court, I know it's be later in the day till noon.
Judge, she's at the hospital. I don't know if she let y'all know that that's where she was.
No, sure.
She's at the hospital right now, so that's,
Why?
I didn't ask her.
How do you know that she's in the hospital?
You know,
Figure out, I guess.
that's where your approach
So
this afternoon.
are you done? Do you have anything else to do?
The reason I came back.
So for now, let's do this. I'm going to allow him to go back. You guys get a hold of her. If for some reason she says that she doesn't want him back, let me know. I'll get in contact with him and then I'm going to modify the order so that he can't go back to the house. I'm going to assume because of the relationship, right? And I don't want to put him on the street, but if she doesn't want him back, then obviously I want to follow the complaining witness's wishes. That's what I always want to do. I don't know if she wants you back. If she does, okay. If she doesn't, but be that as it may, self-control. Because I find that you are mistreating this person, threatening, abusive in any way. And I'm going to tell you now that conduct in and of itself can violate this court order. If I go like this, is that threatening or harassing? It most certainly is, and it'll land your ass in jail. You think it's funny.
No,
Just wait till you get behind and you'll see. I'm trying to tell you that exercise self-control because I will protect every person. And if I find that you become an issue to her, it's not going to go well for you. I will test you 40 days from today. If you test positive for dope, it's not going to go well for you. Do you understand?
Yes, sir.
Okay.
Your Honor, I will let the defendant has been smirking.
I know.
The state's concerned that he's not taking this seriously. Sorry, Your Honor. It's just-
I get it. I get it. Well, he's on notice of what he can and can't do. And the problem is that there are a lot of people on a very fixed income. And I'm going to tell you now that the complaining witness in this case, she's on a fixed income. So you go to jail with a $5,000 to $10,000 bond. Just please admonish him accordingly, April. Okay. So don't worry about filing conditions because it'll be with Felicia. Okay. Oh, no, Felicia,
Yes.
no weapons as well. please. When did we enter the order for the Moab?
We were in court last Thursday. It was initial appearance last Thursday, I believe, or
So my
Wednesday.
question to you is this, is that we have an order for protection that does not allow him to go back to the house and that continues to remain in effect,
Yes, sir.
doesn't it?
Yes, sir, 61 days.
Mr. Lopez, you need to understand this because this is very important. This is something that needs to be researched because you are entering into this agreement where you could be possibly let out within the next couple of days. However, there is an order for protection that has been entered. You're not to go back to this location within that period of time. Because if you do, you could be facing an additional violation of protective order. Do you understand?
Yes, I do.
So, life is way too short to live in fear. And it's not fair. It's not fair that anybody should have to live in fear. You know, you have significant criminal history, and everything here that you've had here is because of no self-control. What's it going to take to get you to realize that you just can't?
Wow, that right there is the heart of this entire hearing. Judge Boyd isn't just handing down a sentence. He's making a heartfelt plea for change. In this moment, he's less of a law enforcer and more of a tough mentor, trying to push someone toward a better path. It's powerful, it's personal, and it shows how justice can sometimes sound like guidance. But here's the real question. Do speeches like this actually change lives, or do they just sound good in the moment? Share your thoughts below.
Off like that? Is it going to take a 15, 20-year sentence to get you to realize this the hard way? Consider this when you're out there. If I say this, what's going to happen? If I do this, what's going to happen? Because you could very well be a 15 to life case the next time you pick something up. It's not hard. If you get upset, walk away. But please, don't let them live in fear. Life's too short to end up in a 6x9 box for the next 20 years. You understand? It's not fair. Especially someone who's raised you, fed you, clothed you, loved you for 20-something years. It's not fair. Consider that. You're charged with terroristic threat of a family or household member. You've worked out an agreement where they're offering you 50 days in jail with credit for the 9 days that you've done. I'd like there to be an affirmative. Okay, there is an affirmative finding of family violence in this case. You need to understand that this is very, very important, because another case like this, there's an affirmative finding of family violence in this case, meaning you can never own a gun or ammunition. The other thing you need to realize is that if you pick up another one of these like this, you could be very well facing a 3rd-degree felony. And because of the pen trips, you pick up another 3rd degree, you could be looking at potentially a 5 to life case, maybe 15 to life. So that's what I'm saying. Be careful. Do you understand?
I do.
They're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement today, there's no turning back. It will go on your record. It's going to be there forever. Like I said, there's an affirmative finding of family violence. So you can never own a gun or ammunition as a result of this plea today. Also, the next one, you could be very well facing many, many years in prison. You understand?
I do.
Do you still want to do this? How do you plead to the offense of terroristic threat of a family or household member? I'm going to find you guilty. I'm going to sentence you to the 50 days, give you credit for the 9. Please, just let them be. All right? All right. Good luck, Mr. Lopez. Thank you, counsel. You too.
Also, just a moment.
Yeah.
Hold on.
There's not a moment.
I don't
Yes,
see
it was. I signed it.
I thought it was.
I only see the motion for the MOAB, not a signed MOAB itself.
I thought it was strong.
Your Honor, on Lopez, I just want to bring to your attention, I'm looking at deeds. I only see the state's motion for the MOAB. I don't see it.
I specifically did a MOAP in this case last time. I don't know why it's not
I
signed.
thought it was addressed.
And I don't see it signed in deeds. Because the motion was on the
Signed last
26th.
time I did it the last time we were here in court. The hell, I need a fly swatter. You see that?
Yeah, I do.
Do you got a fly swatter?
She saw it. Oh, I don't know.
So I'd like to enter it in then,
Not close to it.
you know? So I want to undo the plea.
Okay.
I'm going to enter in the MOA and then we'll do the plea again.
Yes, sir.
Because I want to make sure that there's no issues with this family.
Yes, sir.
All right, coming up, Mr. Lopez.
You got it.
So I didn't sign the plea.
There's no entries, nothing.
Okay, so hold on, let me do the MOA first. So I'm entering in what's called a magistrate's order of emergency protection that identifies Ms. Solis as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of the Bower Creek residence. Do you understand?
Yes, I do.
If you violate this, the state can and probably will file a violation of a protective order. This includes you cannot text them, you cannot message them, you cannot use social media to reach out to them, you cannot use, Snapchat, you cannot use someone else to try to get in contact with them. No contact whatsoever. Do you understand?
I do.
This order is good for 61 days from today. So if you go over there, it's going to be an issue. You understand?
I do.
Okay, so I want to sign first now the MOA,
Okay.
and then after that, we'll now do the plea again.
It's here too, Jack. Judge.
Yeah. Mr. Lopez, I want to protect every person in my county, and I'm going to do it at all costs. Do you understand?
I do.
All right, so let's do this plea again. You're now charged again with the offensive terroristic threat of a family or household member. You're facing up to a year in jail and or a $4,000 fine. They've offered you 50 days in jail, credit for the 9 days that you've done. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers if you're not a citizen. There are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. There is an affirmative finding of family violence. How do you plead on this case? Guilty or not guilty?
Guilty.
I'm going to find you guilty. Now we will sentence you on the case. All right. Good luck to you, Mr. Lopez. Make me proud, man. That's all I'm asking to do. All right. I guess let's just appoint someone else because I don't want to wait. It's already noon. I'm going to give you a PR bond,
Thank you. Thank you, Judge.
but I need to give you a lawyer first before we can start talking about your case.
Yes, sir.
But you got to come back.
I am, Judge. I
Gotta come
promise.
back.
Promise I am. I
Um,
pull out all my hair and everything. I'm my dreads. Pull out all my dreads.
It'll be fun, my friend.
Stressing.
All right, so just hang tight. Sorry. Let me just get him another lawyer real quick. I'm going to bring it back out. We'll talk and then we'll get you out of here.
Thank you, Judge.
Hey, so
Don't send it back yet. I'm gonna have it.
he's still got to come back.
he got a Berg hab, but they dismissed it, right? I mean, I'm confirming with you because that's why the magistrate didn't initially give him a PR bond in this case.
What was his name, Your Honor?
Randall, I'm sorry. No, Randall.
Oh, okay. Excuse me.
Man, 1 second. Abel, we need you, please. Obviously, he'll be right with you.
It's kind of.
So I appointed you a lawyer initially. The lawyer came to reset the case, left. And I don't know if you spoke to him or not. I have Abel here. So you didn't?
No, sir.
Okay.
We didn't talk. Okay.
So I tried to get you another one. I guess they're giving me a hard time about doing that. So I have you now here. I have a great lawyer here standing to help you in the interest of justice because I'm trying to get you out.
Thank you, Judge.
So what happened was you have this theft case from January, okay? You were side on it. You were to come here because they issued you a citation. You were supposed to come here. Apparently, maybe that never happened. I don't know. So that we issued a warrant for your arrest.
Yes, sir.
From what I understand, there was a burglary of a habitation that was charged, that you were ended up charged with, that ended up getting dismissed. And that was the reason why the magistrate did not give him an initial PR bond because of the Berg Hab case. I see now that that case was dismissed 2 days ago because of insufficient evidence. So we're basically holding him on a $100 bond that he's not able to make on a felony that was dismissed for insufficient evidence.
I think he's.
I'm not going to hold you.
Fine.
I'm going to give you a PR bond today. The only thing I am ordering you to do are two things. Don't go to Walmart.
Okay, yes, sir.
Okay? I don't want you going into any Walmart. I'm making that a condition of your bond.
Sir.
I'm giving you a PR bond now, but this is it. If I find that you're a danger to my public, you pick up any new cases, you violate these conditions, I'm going to yank that PR bond in a heartbeat.
Yes,
Do you
sir.
understand?
Sir.
I'm not asking much. Keep my streets
Claims.
safe.
Yes, sir.
Don't become a danger. That's when this happens.
Gotcha, Judge.
The other thing I'm going to do is I need you to stay in contact with the lawyer. So we're going to give you the contact information for the lawyer that you have now. Please try to get in contact with him. If for some reason you're not able to get in contact with him, come back, let us know, and we can take it further. Okay? But technically speaking, you were supposed to get into contact with your lawyer within 24 hours of you being appointed a lawyer. We're going to give you his phone number. Please reach out to him. If you're not able to, just let us know and we'll take it in a further direction.
Gotcha, Judge.
If you have any questions, I have Abel here to help you. You can always ask him and he can answer any questions. He's capable. I trust him with everything that we do.
Sir.
Let's not talk here now because, I don't want you to talk in front of everyone.
Yes, sir.
You guys keep it. So,
Who's the attorney?
well, I don't want to say that.
Okay.
now. So, but do you mind? So regardless, probable cause has been found in your case now as it is.
Sir.
Okay. So would you mind filing conditions of no going back to Walmart, please?
Sir.
I think probable cause has been found, right? Yes, it has been found. Okay. All right. So any questions you have, I'll direct it to him for now. And then in the reset that we have, I'm going to circle the phone number so that you have the phone number for the lawyer that we have. Just please, when you're released, get in contact with them so you guys can get on the same page. You have to, I'm going to make you, so I want the next appearance required so that we know that they're on the same page. So your next setting, you have to be here, come back so we're all on the same page. After that, I'll waive your appearance.
Yes, sir, Judge. Yes, sir, Judge. Thank you,
Look,
Judge.
Mr. Randall, please be safe, man.
Yes, sir.
Mr. Ray, I'm going to still send you said for the bond.
Yeah, yeah.
And after they bring me back down, those.
Mark.
Badon, B-A-D-O-N. So just so that, he tried to fix his license. He went and did all stuff with DPS. He found out he's got a issue out of Sugarland, which he's taking care of. He just needs more time.
Yeah, but I mean, we're at 783 days. At what point do we say when?
But you said 7.
Huh?
I thought you said 7.
No, 783
Past
days.
Even right, Judge?
Hmm?
There's no way that I've been on for 700 days.
No. You've been on since like February, beginning of February, but I told him that he had 30 days to do whatever he wants to do. But how do I know he's going to fix the stuff in Sugarland within a reasonable amount of time? Like not going to take 3 months here? No. So we need to figure out where is she here?
He's here. Talk to him and see if it's believable.
So no, what I'm going to do is, I guess, do you have an offer on this case?
No, but I'm sure there were time served.
Well, I'm willing to give a little bit of time, but I'm not going to go crazy. It's already nearly 800 days old. So I need to get a date. Are you Mr. Badon?
Okay.
Come on up. I'm willing to give you a little bit of time for you to try to fix your license. But your case is nearly 800 days old. It would be unreasonable for me to let you just sit here 3 months, 6 months. So we need to put a time limit on this by what day you need to have this done by.
I paid my surcharges already. I just need to start a payment plan with Sugarland and that's it.
Okay, but when is this going to happen? If you even do that, will that lift the ineligibility of the license anyways? Do you know?
Yes.
You've reached out to
I talked
DPS?
to them already, yeah. Yes, sir.
Okay, I don't want to know, but we need to put a date certain when the last day for this case ends, where you either get done what you need to get done, or you end up taking something on this case. But I'm not going to just hold this open indefinitely, even considering that it's 800 days old nearly. So Alex, is there an offer on this case?
These are two PTI offers, Your Honor, and both of them are contingent upon the driver's license being valid.
Okay, so You reached out to DPS.
Yes, sir.
They've told you what you need to do to get it fixed.
Yes, sir.
Okay, I'm going to give you 3 weeks. You get no more time after this time. Do you understand? At 3 weeks, it's D-Day. If it's not done, then we need to move on. But yeah, I'm gonna either set your case for trial or you gotta accept the plea bargain agreement. Do you understand?
Yes, sir.
So, Marco, this is the last reset that I'm doing. I'm not doing any more. You need to do what you need to do today because it takes forever for stuff to reflect in DPS's system. That's why I'm giving you the 3 weeks because you need to take care of it today. Because if you wait till the last minute, it's not going to reflect in DPS's system. It takes 2 weeks for them to just upload stuff to get it changed in the system. You understand? Okay.
Thank you, Judge. Appreciate it.
Good, how much time like that?
3 weeks and then clear trial. The next setting. You are Miss Owuma.
Sir.
Ma'am, you are charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On February 25th, officers were dispatched to a minor crash with a disturbance at the 1000 block Upland Drive in Harris County, Texas. The officers made contact with 2 witnesses. The second witness stated she was driving her Lexus north on Upland Drive when the defendant, the sole occupant of the vehicle, was driving her black Camry south in the northbound lane. The witness stated she slowed down, honked to alert the defendant, and crashed into her car in front of him while going north. The first witness stated he was in the southbound lane and was stopped waiting to enter the service road, and the defendant driving her Camry struck the Lexus, and after the 2 motor vehicles crashed, the defendant swerved right and then ran into the back of the Chevy Blazer the first witness was driving. The first witness stated the defendant appeared to be looking down like she was slumped over, and the first witness approached the motor vehicle, and the defendant appeared drunk. The defendant tried to drive off, and the first witness was telling her to stop and wait. The second witness corroborated the first witness' statement and stated she could smell a strong odor of an alcoholic beverage and that the defendant was drunk. The officer made contact with the defendant, and the defendant stated she was driving her car, had left home, and was on the way to the hospital for her ulcers. The defendant stated she was on the right lane going south, and a lady in an SUV was going north in her lane. The defendant stated she swerved over and hit another car. She tried to exchange information and get off the roadway, but was not trying to leave the scene and only wanted to move the cars into the parking lot on the west side of the road. The officer observed a moderate odor of an alcoholic beverage, glossy eyes, slurred speech, and swaying. The defendant was within normal parameters regarding her vital signs per Houston Fire Department, and standard field sobriety tests were then conducted. HGN 6 out of 6, walk and turn 5 out of 8, 1 leg stand 3 out of 4. The defendant was read the DIC and consented to blood.
All right. So we have a DWI here. Any more DWIs anywhere else? If you run her NCIC, please.
She only had a previous out of 2022 here in Court 5, but that's the only one, Your Honor.
Does she have a valid Texas driver license?
It's not eligible, Your Honor.
It's not eligible. I want to make something perfectly clear to you, Ms. Wuma. I'm ordering you as a condition of your bond not to drive any vehicle whatsoever for any reason unless you have a valid Texas driver license and liability insurance. I'm also placing a restriction on your license that you're not to drive any vehicle that's not equipped with an ignition interlock. I'm sending notice to DPS in Austin so that every single police officer knows if you're caught driving a vehicle and it doesn't have an interlock in it, they will arrest you and put you in jail. Do you understand? And then I'm going to revoke this bond here as well. You will be signing an affidavit with me today. Counselor, did you want to add something?
I managed the law. That's incorrect. The cop did not say moderate. He said mild. Or about.
Sure.
Yeah, Judge, a minor automobile accident and a mild odor of alcohol is not any kind of probable cause for intoxication. I believe what happened was the police officer noted she had a prior conviction and then jumped to conclusions and ran everything backward from there.
Well, we have witnesses who say that she's possibly intoxicated. They do field sobriety tests. The field sobriety tests indicate that she's intoxicated or potentially intoxicated. So that's when they do the blood test. This is just a mere probable cause hearing. We have someone who's got indicia of intoxication, slurred speech, odor of alcohol, crashes into 2 different cars, fails 3 different field sobriety tests. You've got 2 other witnesses that say that she's possibly intoxicated, who they're on the scene and see it. there's more than enough to go forward for probable cause purposes. Beyond a reasonable doubt, I don't know. That's why we wait for the evidence to come in. But I think that there's certainly sufficient probable cause to go forward. They say you don't have a license, so you may not drive at all for any reason. I don't care what your justification is. I don't care if Bambi has to go to the hospital. You need to save 30 kittens. A kid needs to go to the, you cannot justify getting into a car for any reason. Do you understand? This is an affidavit that you're going to be signing today, promising me you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months of jail and a $500 fine every time you drive because it's an offense in and of itself. Do you understand? Because you don't have a license, because we're ordering you not to drive, I am now ordering you to obtain a portable breath test device that you're going to take with you everywhere you go to prove to us that you're not consuming alcohol. You're not to consume alcohol, illegal drugs, unprescribed controlled medication, and we will randomly test you as well. Now, good job on having a lawyer because you have one. I will waive your appearance, but it is your responsibility to stay in touch with them. If they tell me they can't get a hold of you because you're playing games and you're dodging phone calls, whatnot, I will issue a warrant for your arrest. All I'm trying to do is protect my city at all costs, and I will do it however I can. Do you understand? If that means putting you in jail because you become a public danger, I'm going to do it in a heartbeat. So for now, what I'm going to have you do is I will have you come up here, swear to us that you're not going to drive. Then I will get you to Victoria, where we'll have you sign a reset. You will get with Felicia for your bond conditions, and after that, you guys are free to go. All right?
Thank you, Judge.
Okay, guys. Thank you, sir. Salgado.
Yes, sir.
Ma'am, you were charged with assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Yes, Judge. The complainant and the defendant are mother and daughter, and the officers were dispatched to a residence in Harris County, Texas, in response to a family disturbance. The complainant told the officers that she arrived home to find the defendant packing her things. The complainant began discussing the defendant's life choices, which led to an argument. The complainant tried to get the defendant to stay at the home, but the defendant grabbed the complainant by the shoulder and shoved her against the wall, causing pain.
Ma'am, I'm going to find that there's enough probable cause to go forward with your case. Do you guys have the rip done?
There is a rip done, Your Honor.
What
Yes,
does
Judge.
mom want contact with her?
It's my understanding she's okay with contact.
She wants contact, Your Honor.
Is she here now?
No, she lives in a separate home. Since that incident, she's moved.
So I want you to understand something, Ms. Salgado. I'm now entering what's called a magistrate's order for emergency protection. This is a court order that identifies Ms. Gonzalez as a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Do you understand? If you violate this court order, the state can and probably will file a violation of protective order, and that is one of the worst misdemeanor cases that you can pick up. So just be nice. If you butt heads constantly, find another way. Go outside, do something else. But if you guys get into it again and there are threats made, you might end up back in jail. You understand? So this usually comes with a residential restriction that you cannot go back to the house. I will take this off. I am ordering you not to have any threatening or harassing contact with her. What is threatening or harassing doesn't matter what you think. It's what she perceives. So conduct in and of itself can violate this. You understand? Do you mind filing another threatening or harassing?
Yes, Judge.
Please. So bond.
Judge, we are asking for $100 pretrial bond. She has no history. Once she found out about the case, she hired us, and we're here presenting ourselves and availing ourselves to the court's jurisdiction. I don't think she's a flight risk or a threat to the community.
Response?
And Judge, there is no criminal history, and
Okay.
given the complainant's statement to us, we wouldn't be opposed.
Okay, so I'm with you. I'll set bond at $100,
Thank you, Your Honor.
and then I'm going to grant you a PR bond. That means that I'm giving you a free bond today. But understand that I'm going to protect my community at all costs. If I find that you become a danger to my community, I will revoke that PR bond, issue a warrant, and put you in jail. No more. You will not get any more. Do you understand? Now, because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them, and they will tell you if and when you have to come back to court. Okay? All right, so I'll have you sign a reset with Victoria. We'll have you get with Fleischer for your conditions, and then you're free to go. Okay?
Judge, may we be excused briefly?
So, PR bond and $100. Good morning, Mr. Wally.
Good morning.
So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement. They're offering you 6 days in jail with credit for the 2 days that you've done. Are you sure you want to do this?
Yes, sir.
I guess the prior evading is what,
Sir, we talked about everything, wanted to
just,
do this, right?
you need to understand that this has lifelong consequences. You know, you're entering into this agreement where this DWI will go on your record. It's going to be there for the rest of your life. It's even there after you die. The reason this is important is because if you get pulled over in the future, an officer will look at your record. They're going to see that you have a prior DWI. If they roll up to your window and they smell alcohol, they smell dope, it's probably not going to go well for you. Do you understand?
Yes, sir.
And from now on, what we're doing today, the proverbial slap on the wrist, from now on, it's a minimum of 30 days in jail. Do you understand?
Yes, sir.
So what I'm trying to tell you is that if you want to get lit, just don't get into a car because it's a huge risk you're taking. You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this, it's done forever. This is what you want to do. How do you plead to the offense, sir? Guilty or not guilty?
Guilty.
I'm going to find you guilty. I will send you to the agreement. I'm going to suspend your license for 90 days. Do not drive until you get a license. The other thing is this, Mr. Wally, is that DWI is big business. There's a $3,000 surcharge that tacks onto this because you pled guilty to this. I'm going to waive it for you today. But the DWI second is a $6,000 surcharge. So if you're not smart enough to consider how to get home on a night of drinking, get ready. It's minimum 30 days and a huge surcharge. Do you understand?
Yes, sir.
All right, good luck.
Your Honor, could you run the LR suspension, or the suspension concurrent with the LR suspension he already has? He had a suspension from October to April. We have the dates. 6 months, Your Honor.
I don't know, man. He has a prior evading that
No,
just,
that was the same transaction. They dismissed it, I believe, like the day after.
Y'all print it out or it's all in the trunk?
It was the
it's
same.
out of the same, okay, all right. I will. Okay, all right, you got to get them the dates.
Yes, sir.
All right,
Thank you.
good luck, sir.
Thank you, John.
You got it, man.